Hi everyone. In this week's video, we're going to be looking at subject access requests. So the nightmare letter that comes in to HR departments and data controllers from employees. Can I have access to any personal data held about me, which triggers a potential panic about hundreds of thousands of emails having to be searched. More specifically, we're talking in this video about requests which involve data identifying third parties, so where we have potential personal data to disclose, but where the rights of other data subjects may be compromised as a result. Now, data protection legislation, by its very design, is to ensure the protection of privacy, and there is a clash of rights if, in responding to one person's request, we might need to disclose information about another individual, potentially prejudicing their privacy. So an example might be an email about an employee's work being poor. Arguably, the data subject making the request is entitled to that information because the subject is about them and identifies their poor performance. But the information in terms of the manager making the comment is also their personal data as well. In those circumstances, employers are not required to disclose such information unless either that second individual has consented or it's reasonable to disclose the information without that consent. So there are three main issues that we need to consider. Does the request require disclosure of information that identifies somebody else? If so, has that person consented? And if not, is it reasonable to disclose in any event? First, most obvious question is somebody identified from this document? If they are identified as the source of the information, for example, in the performance management email, they are the person who has written that email identifying concerns. It might not explicitly identify that individual, but if it is obvious in light of reading that information who that relates to, and the view could only have been given by that manager, then it's likely to identify that person as an individual and will result in them treating that email as their own personal data. If a third party is identifiable, has that third party consented? If so, we must disclose the information to the individual making the request. The Information Commissioner's Office take the view that it's a good practice to seek consent, but not necessarily mandatory to do so. It might be impracticable or inappropriate. So if, for example, that third party has now left the business and we don't have contact details, if it would bizarrely disclose information from the person making the request that they were not already aware of, or if it's inappropriate to know that that third party has made a subject access request, it might be inappropriate to make contact. If consent has not been given or has not been requested, is it reasonable to disclose without consent is the third part of the test. No definitive answer on this because each case will depend on its own facts and each document will be interpreted differently, but we have to have regard to circumstances including the type of information disclosed, any duty of confidentiality that we might owe in relation to that document and to another party. Any steps taken to seek consent, as we've discussed, whether the individual is capable of giving consent, and whether there's been any express refusal of consent. Helpfully, case law has confirmed that data controllers need to be afforded a wide margin of appreciation when reaching evaluative judgments between privacy rights and other interests. So no black or white answer here. I think what's key is that we have some sort of reasoning or documented trail to show why we've arrived at a decision to restrict disclosure, if that's the decision we're going to make. There's no obvious priority between the interests of the person making the request and anybody objecting to disclosure of the documentation, so nobody takes priority in those circumstances. And the fact that the individual making the request is doing so in relation to proposed litigation should not interfere with the assessment the data controller is making. So simply because somebody says, I'm going to present a claim, I want this information, it does not follow that automatically means we've got an obligation to disclose. We might, if we do make a disclosure, want an undertaking or a promise from the employee that it's not going to be disclosed any more widely. What we don't want is a data leak, a data breach. So if we are disclosing third-party information, it cannot go beyond the individual making the request. So we need to look at all of those factors when considering whether to disclose, and we need to look at the importance of context as well. If consent is not given, it may be reasonable to disclose information where that other individual's role includes line management responsibility. It will be more difficult if the request is made in relation to duties of confidentiality or to a complainant, or the consequences that might occur if we make such a disclosure. So it's extremely difficult to give definitive answers as to whether a particular document is capable of falling within the scope of disclosure request. First and foremost, if we can get consent, brilliant. If not, can the document be redacted? So can we make adjustments which would provide the personal data to the person making the request, but not necessarily identify a third-party individual? If not, is there any reason why we would say it's reasonable to withhold disclosing that information? And if we do want to rely on any reasoning, maybe put that down in writing, because if there is a subsequent complaint made to the ICO, we can justify how we've arrived at that decision. Hopefully you found this useful. If you do want further advice on any data protection issues, our employment and our regulatory teams can advise on the same. Visit the website chadwicklawrence.co.uk for more information, or email employmenthub@chadlaw.co.uk. Thank you.